Yesterday, we broke down Charlie Adelson's appellate attorney's motion in the Court of Appeals to relinquish jurisdiction so that they can send the case back to the trial court level. And then in the trial court level, they will then file a motion to vacate the sentence, vacate the conviction, and move for a new trial for Charlie Adelson. All this based on the ineffective assistance of counsel. This is the argument that they're making, that Dan Rashbaum was ineffective because he had a conflict of interest. There was a conflict of interest that we all saw play out, that he was representing both Donna Adelson and Charlie Adelson, and Charlie Adelson seemed to have rescinded any sort of waiver if he ever did give one, and therefore he was conflicted out. He had to withdraw. But Charlie Adelson's team is now arguing that really Dan Rashbaum was conflicted out way before this. He wasn't just conflicted out right before Donna Adelson's trial. He was actually representing Donna Adelson before Charlie Adelson's trial. And if he is representing both Donna and Charlie before Charlie's trial, well, then he is conflicted out, and therefore he is going to be considered ineffective. And if he's ineffective assistance of counsel, that is the basis for a new trial. So again, what they're asking for, and I did a whole explanation on this in our last video based on this entire motion that Charlie Adelson's appellate attorneys filed. Today, we're going to be discussing the state's response to that. But again, their motion is based on primarily some case law, which stands for this proposition that even when you have an appeal going on, you can ask the Court of Appeals to pause everything, relinquish the jurisdiction, send the case back to trial, the trial court level, and then allow Charlie Adelson there in the trial court level to file this motion to vacate the judgment, vacate the sentence, vacate the conviction, and have a new trial. So that's what they're asking for based on Dan Rashbaum's conflict of interest. All right. So we're going to be jumping into the state's response today in just 1 minute. Before we do, I wanted to show you a quote from one of the cases that they actually cited, that Charlie Adelson's team actually cited in their brief. They cited this case, but I don't know if they actually looked up the entire case themselves, because if they would have, there is some great language, a great quote from this case that they should have mentioned in their brief. So I'm going to show it to you. So this is what it is. Let me just pull it up right here. All right, here it is. So this is taken out of this case of Combs versus State. Now, they actually cited Combs versus State, which is, they didn't really cite directly to Combs versus State. They were actually really citing a different case, Jefferson versus State, which actually cites Combs versus State. But if they would have looked up Combs versus State itself, this is what it says. Look what it says right here. If appellate counsel in a criminal proceeding honestly believes there is an issue of reasonably ineffective assistance of counsel in either the trial or the sentencing phase before the trial court, that issue should be immediately presented to the appellate court that has jurisdiction of the proceeding, so that it may be resolved in an expeditious manner by remand to the trial court and avoid unnecessary and duplicitous proceedings. So you see clearly this case says that this is a Florida case, which says exactly what you're supposed to be doing. Immediately, it should be presented to the appellate court, which is exactly what they're doing. And then, of course, like we spoke about in the previous video, that the appellate court has the discretion what to do. They could send it back to the trial court if there is an honest belief and that the motion is not frivolous and there's actually something to be discussed. Maybe there needs to be an evidentiary hearing. So then they have the discretion to send it back to the trial court. So a great quote from this case. It really says exactly what should be done. It should be immediately presented to the appellate court that has jurisdiction of the proceedings, so that it may be resolved in an expeditious manner by remand to the trial court. So that essentially they're saying, this is what you should do. You should remand it to the trial court. So this is a great case. They should have mentioned it. They didn't. So next time they should always ask brother counsel's advice. Okay. So now let's go into the state's response to Charlie Adelson's motion. Let me pull it up for you. All right, here we go right here. So here we go with the state's response to appellant's motion to relinquish jurisdiction to the trial court. Charlie Adelson has filed a motion to relinquish jurisdiction to the trial court in Leon County. While Adelson's motion is unclear as to what specific proceedings he seeks in the trial court below, and it was not unclear at all, but they're trying to argue that, Adelson appears to be pursuing a claim of ineffective assistance of counsel while his appeal is pending. Okay, it was very, very clear from their motion what the basis was. So I'm not sure why they're trying to call them out here, trying to, throw some mud, but I think if you read it, it's pretty clear what was going on. So anyway, moving on. The state objects to Adelson's motion to relinquish because it is procedurally barred. So this is their first argument here. They're letting you know about what their first argument is. Their first argument is that there is a procedure problem here, meaning even if you are right on all the substantive parts of your motion to relinquish jurisdiction, but since you didn't follow the actual correct procedure, that is why the Court of Appeals cannot send it back to the trial court. That's essentially what they're saying. And Adelson has failed to demonstrate a valid reason to circumvent the normal procedures for post-conviction relief under Florida Rule of Criminal Procedure 3.850. So you didn't give us a reason. I mean, there's a normal procedure here. The normal procedure is that after everything is done, all the appeals are done, then you can go and file a motion for relief of judgment under this rule of Criminal Procedure 3.850. So they're arguing right away. You're seeing a little bit of a hint of where they're going with this. Number one, you're procedurally barred. Number two is that you didn't give us a good enough reason, meaning I guess there's some sort of case law that they're going to be citing, or they should cite, that this is not the normal procedure. And if you want to follow the normal procedure, then you would be waiting for all the appeal work to be done. And then after that, you can go ahead and file this motion for post-conviction relief. Now, that case that I just cited for you seems to actually hold just the opposite, that right away you should remand it to the trial court and not to go through the entire appeal process. Okay, but let's continue. Issues presented. Charlie Adelson's motion presents two issues for this court to consider. First, can Charlie Adelson pursue his conflict of interest claim while his direct appeal is pending? That's the first question, right? It can't even do this. Can you now file a motion in the trial court level when you have a direct appeal pending? Okay, so that's the first question. And like we've cited all those cases in what Charlie Adelson's team has cited already, and which we explained in our previous video. If you haven't seen that, definitely go check that out. But it says pretty clearly that you are allowed to. There's this mechanism called relinquishing the jurisdiction. But anyway, let's continue. Second, if Adelson can pursue his claim during the pendency of this appeal, should this court exercise its discretion? Again, it's all discretionary. So should this court exercise its discretion to relinquish jurisdiction to the trial court? Okay, so now we go through some of the procedural history. We already know the procedural history at this point, everything that happened on the eve of Dan Adelson's trial. So he had to bow out. Dan Rashbaum had to withdraw. Charlie Adelson rescinded his waiver. As you see here, Charles Adelson rescinded his waiver of conflict of interest. This led Rashbaum to remove himself as Don Adelson's attorney in a murder trial. Now, Charles Adelson claims that Rashbaum's representation of Don Adelson infected appellant, meaning Charles Adelson's trial. That's exactly the language that they used in their motion. According to Charles Adelson, his case should be relinquished to the trial court for some type of hearing. Again, they're trying to pretend that this type of hearing doesn't exist. And they're trying to some type of hearing. Okay, it's very clear in the case law what this type of hearing is. It's a 3.850 hearing. And I don't think it's helpful to the state to try to be snarky with this. I appreciate snark. I definitely do. But when it's clear as day what type of hearing this is, then don't try to say, oh, they're asking for some type of hearing. Come on. Everybody understands what's going on here. So it's not helpful. And I think it's just not great brief writing in this point. Now, again, like I said, sometimes it's worthwhile to call out the other side to show how they're asking for something ridiculous. But here, it's very clearly not ridiculous. The case law is clear that you're allowed to ask for this specific type of hearing in the middle of an appeal process. But okay, let's continue. Adelson relies primarily on State versus Benessis, which said that appellate courts have the discretion to relinquish jurisdiction to a trial court so that a defendant may pursue a 3.850 claim. So, and then literally the next sentence after they say some type of hearing, they literally say exactly what the hearing is, and they quote the case law for it. So again, I don't love this specific style of brief writing for this specific issue. Okay. All right. Then let's continue. The state opposes this motion and asks this court to make Adelson follow the normal route of pursuing a 3.850 ineffective assistance of counsel claim. Okay. Now they're going to have to show some case law that the normal route is something different. Okay. So let's see if they do that. Let's continue. Adelson's conflict of interest claim should be handled as a post-conviction claim of ineffective assistance of counsel. Okay, post-conviction just means post-conviction claim is just after everything is done. After all the appeals are done, after everything is done, then they can go ahead and file this motion. Adelson's motion fails to explain what he would accomplish by having his case returned to the trial court. Well, does that motion actually fail to explain that? No, it explains it pretty clearly. It says, to save all the judicial resources and for judicial economy, it definitely makes a lot of sense not to go through the entire appeal process and have all this time wasted on an issue or all these other issues where there's a different, very important issue which completely can make all of these other issues moot. That makes a lot of sense. So he did explain that very clearly. So again, if the other side is taking a ridiculous position, I am all for calling them out. I am. But if you're calling out something which is very reasonable, and they actually explain very well in their brief, not a great tactic. But let's continue. Adelson does not allege that a hearing is necessary to establish a claim cognizable in this direct appeal. To further the confusion, Adelson's motion does not state that he is moving under any rule of criminal procedure. Now, technically, I don't believe that the actual words of "we are moving under rule of criminal procedure 3.850 exists in their motion, but it's so clear from all the case law that they cite, and the case law that they cite, like Meneses, does talk about the Florida rule of criminal procedure. And they do say very clearly that we're moving under Meneses and State versus Jackson or Jefferson, and all the other cases that they quoted, Libby, all those cases, they're saying we're moving under those cases. So if they're moving under those cases, which incorporate rule of criminal procedure 3.850, so then don't try to play this game of we don't even know what rule of criminal procedure they're moving under. I don't think it's a great tactic again. All right, but let's continue the response. Instead, Adelson simply quotes old case law where appellate courts have relinquished jurisdiction for a defendant to pursue a claim under Florida rule of criminal procedure 3.850. So yes, they did quote some old case law going back into the 1980s. Not really, really old, but still old. And again, just because something's old doesn't mean that it's outdated. All right, just in the world of case law, old cases can have very, very strong precedential binding precedent. So it's presidential authority. So it definitely is not an issue, but let's see if they're going to argue something different. The only plausible 3.850 claim that Adelson can make based on Rashbaum's conflict of interest is ineffective assistance of counsel claim. Yes, that's exactly what they're arguing. The best procedure for handling such a claim is a collateral post-conviction proceeding after Adelson's appeal is complete. Do they have some sort of authority for that? This is the best procedure. Where did you come up with this idea that this is the best procedure? This is just you talking? Is this just your own idea? What you gotta, this is the court of law. So you got to provide some sort of authority when you're arguing against the other person's position and you're saying, well, there's a better procedure here. Do it after post-conviction. Where do you find that? Cite some sort of case law. So cite some sort of rule. All right, let's continue. Adelson's motion to relinquish fails to satisfy the holding in Stiger versus State. Now, if you really want to do this right, here's what I did this. You look up Stiger versus State. You read that entire opinion. And this really is a very, very strong part of their motion. This is really what they're relying on, the state, after all of this stuff before. This is what they're really, when you're talking about case law, this is the case that they're relying on, Stiger versus State. So I know some of you like to look up the case law yourself and not just rely on me, which is great. But the fact that we're actually even talking about case law is obviously a plus. That's what we do on this channel. But yeah, so look up Stiger versus State. It's actually not such a long opinion. And this is really what they're relying on. And I'm going to tell you what I think one of the issues with the state relying on Stiger versus State is. But let's first get to their argument. Adelson's conflict of interest argument is no more than a premature claim of ineffective assistance of counsel. No, it's not a premature claim. It is a claim of ineffective assistance of counsel. That is exactly what they're doing. And you actually acknowledged that before. But anyway, let's continue. While Adelson relies on Meneses for the proposition that appellate courts may relinquish jurisdiction to trial courts so a defendant can pursue a 3.850 claim, okay, just one thing very clear. Everybody agrees, and it's straight out, that 3.850 includes arguments of ineffective assistance of counsel. Okay, 3.850 was just the rule which allows you to move to vacate a sentence, vacate a conviction, vacate a relief of judgment. Included in one of the reasons that you're able to move for 3.850, this motion to vacate, is ineffective assistance of counsel. That's agreed on. Everybody agrees with that. The issue in Meneses was a Brady violation, not ineffective assistance of counsel. So here where they're arguing that even though Adelson's relying on Meneses, and Meneses does stand for this proposition that the appellate courts can relinquish jurisdiction, the issue in Meneses was a Brady violation. Now that is true, that the issue in Meneses was a Brady violation, but does that make any difference? And in fact, they cited a number of other cases, and especially the case that I just showed for all of you, Combs, which says specifically that ineffective assistance of counsel is included in this type of motion to relinquish jurisdiction. It can be filed. So this distinction is not a great one. It's a distinction, but we call it a distinction without a difference. Okay, so there's no difference. The Supreme Court of Florida's decision in Stiger versus State casts doubt on whether Adelson can still rely on Meneses to obtain a mid-appeal hearing on an ineffective assistance claim. So they're saying, okay, Meneses, number one, was a Brady violation, which I told you doesn't make a difference anyway. But now we have this case called Stiger versus State. Well, is Stiger versus State a recent Supreme Court case? And the truth is that it is. So remember, if you have a 1980 case in Meneses, and then you have a 2021 case in Stiger, and Stiger says something different than Meneses, guess which one we follow? We follow Stiger. So they may be onto something here. They may be onto something. So let's see what they're onto, and we'll see if this may carry the day. 40 years after Meneses was decided, so 40 years, I think that's 2021, the Stiger court held that ineffective assistance of counsel claims may only be raised on direct appeal in the context of a fundamental error argument. Okay, so when can issues be raised on direct appeal? That is in the context of a fundamental error argument. We're going to discuss that soon. I want to give them some more of a chance to develop this argument before I give you my 2 cents of what Stiger really stands for. The Stiger court also held that a post-conviction proceeding is the proper vehicle for ineffective assistance claims under Strickland versus Washington. Ineffective assistance of counsel claims relying upon the less demanding Strickland standard are properly considered upon the filing of a legally sufficient post-conviction motion in the trial court. So finally, we get to some sort of case law, which they say, really, you should wait for the end of everything and then assert your ineffective assistance of counsel claims. Now, I do want to tell you, because if you follow this all, you go through Stiger, and then Stiger is going to quote Strickland. That's exactly what happens there, and that's what they're quoting. They're actually quoting a quote from Stiger, which is quoting Strickland. Okay, if you actually look up Strickland, what happened in Strickland is they're discussing, Strickland was actually a United States Supreme Court case. They're discussing an ineffective assistance of counsel claims that don't have to do with conflict. Okay, does not have to do with conflict of interest. They actually say that straight out in the opinion, that we're not going through this whole analysis when you have conflict of interest. Conflict of interest, they send you to a different case. Okay, so this is a little misleading, and that's what I was telling you a little before. It's a little convoluted and nuanced, and you have to really understand which case is talking about what specific area, and if they actually say that, it makes a difference. Like we said, Meneses, even though it's a Brady violation, but it's clear that that's not the only reason that you're able to move for the appellate court to relinquish their jurisdiction. It's very clear from other cases that you are allowed to move also for ineffective assistance of counsel claims, not just Brady. Okay, so you have to know when it makes a difference, when it doesn't. Well, Strickland, if you look it up, and please, by all means, fact check me on this, Strickland versus Washington says specifically that ineffective assistance of counsel claims that they're going to be analyzing is only when it does not have to do with conflict of interest. Okay, so anything about Strickland is not really so relevant to this specific issue. And for conflict of interest, they send you to a different case called Coulier versus Sullivan, or Kyler versus Sullivan. So you can take a look at that case also if you really want to do your homework on this properly, which I did, but I doubt a lot of other people did what I did. But anyway, so But if you want to, this is what you really need to do if you really want to understand what's going on here. Okay, so we got Strickland, and this is what they're arguing, that Strickland says that you should really, everything should be post-conviction. This motion should be filed. And again, they're quoting Stiger versus State, a 2021 case. So now, Stiger, what does Stiger say? At a minimum, Stiger narrows the holding in Meneses. So what they're saying is the minimum is that Stiger's 2021, Meneses is 1981. This is 40 years later, and Stiger is narrowing what Meneses is saying. So you're right. Essentially what they're saying, what they're arguing is, you're right, Meneses does say what you're arguing, but Stiger now changes that. It narrows the holding in Meneses by severely limiting the ineffective assistance of counsel claims that may be raised on direct appeal. Now, what are the requirements of Stiger? So now they're going to go through the requirements of Stiger. Adelson's motion to relinquish fails to meet the requirements of Stiger because the motion does not allege fundamental error. Now, that's a very important term. Fundamental error. What does that mean? So we're going to see, they're going to actually say exactly how the Stiger case explains what fundamental error is. But the Stiger case definitely says that if you want to pursue a ineffective assistance of counsel claim in a direct appeal, then it has to be a fundamental error. Okay, now let's just continue, and then I'm going to give you all this. I'm going to explain it all after we're done with this, but I want to give them a chance first. To establish fundamental error, Adelson must demonstrate an error that reached down into the validity of the trial itself, to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error, meaning the jury could not have found Charlie Adelson guilty because of this error that you're claiming was Dan Rashbaum's ineffective assistance of counsel, which presumably what they're arguing here is that it would be if he wouldn't have called Donna Adelson, perhaps. And he took Donna Adelson's off the witness list. That's the argument here, right? Okay. Thus, if Adelson wishes to bring an ineffective assistance of counsel claim on direct appeal, he must allege and demonstrate that Rashbaum's conflict of interest caused the jury to convict Charlie Adelson rather than acquit him. That's what the case law, that's fundamental error. It's so fundamental that the verdict of guilty could not have been obtained without the assistance of this error. Okay, so yeah, this is a correct summary of the law. Adelson's motion to relinquish fails to allege or demonstrate that Rashbaum's conflict changed the jury's verdict. So it's not enough. They're arguing your motion, very nice. He took Donna Adelson off the witness list, and that could have been because of the conflict of interest that he had. But with Donna Adelson having testified and to corroborate Charlie Adelson, would that have meant that the jury's verdict would have been absolutely innocent instead of guilty? No. And that your motion doesn't even argue that. Instead, the motion merely claims that Rashbaum's conflict of interest infected Appellant Adelson's trial. So all you're arguing, this is a direct quote from their motion, that all you're arguing is that it infected Charlie Adelson's trial. The Florida Supreme Court decision in Stiger makes clear that this allegation of infection is insufficient. Infection does not equal fundamental error. So therefore, this allegation of infection is insufficient to warrant the relief Adelson seeks under Meneses. At best, Adelson's claim that Rashbaum's conflict infected Charlie Adelson's trial alleges a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different, and that's the quote from Strickland. Strickland, the Stiger decision requires Adelson to raise a Strickland claim in a collateral post-conviction motion. So this is something they're arguing. Okay, you want to argue not based on fundamental error? Well, then that falls within Strickland. And remember what we said about Strickland, right? Strickland doesn't really apply to conflict cases. But nevertheless, this is what they're arguing. They're arguing that Strickland would be different. And under Strickland, you can't raise it now. You got to wait for a post-conviction motion, which is after all the appeals are done. Okay, so let's pause it right now. And I'm going to tell you what the problem with Stiger is. And they're really, really convoluting two things. And it's tricky and it's a little confusing, but once you start actually researching the law, which is something that more people should do before they talk about this, once you start researching the law, then you see why Stiger really doesn't have anything to do with Meneses. Okay, so what is the Stiger court talking about? Okay, they're literally convoluting two issues, separate issues, and it's a little nuanced, so just follow me here for a minute. The Stiger court is talking about the following scenario. The scenario in the Stiger court was that there was no objection or preservation of an ineffective assistance of counsel brought up at the trial court level. Okay, so something that we understand from appeals, something you have to understand it from as an appellate attorney, is that anything that wasn't preserved in the trial court, meaning you didn't make an objection, this is something that we're seeing and play out in the Karen Reed case, right? If you don't make an objection on the record to any sort of specific ruling, well, then you're going to be really, really challenged to bring that up again at the appellate court level. You got to preserve your objections, and then if you get overruled, then you can go ahead and appeal that ruling that overruled your objection. Okay, so Stiger court was dealing with, there was no claim that there was an ineffective assistance of counsel. There was no argument for that made at the trial court level. And then what happened is that in the appeal, they wanted to bring up ineffective assistance of counsel claim. So now trial court level didn't mention it. Now you want to mention it in the appeal and make that an issue of on appeal. Well, how do you do that? So that's what Stiger was dealing with. Can we just bring up issues to the appellate courts where you didn't preserve the issue at the trial court level? And the Stiger court said, yes, in certain circumstances, when the error is fundamental. So when the error is fundamental, then you can bring it up in the appeal court, in the appellate court. So again, if you didn't argue at all at the trial court level of ineffective assistance of counsel, then Stiger is the holding of Stiger is that you could bring it up at the appeal level, even if you never made a mention of it, but it has to be a fundamental error. And we see how incredibly high that burden is. But does that have anything to do with a motion in the appeal court to relinquish their jurisdiction? Does it have anything to do with that? And when the Florida courts should grant that motion or should deny that motion? And the answer to that is no. In fact, if you read the Stiger opinion, it's clear they're not talking about a motion to relinquish jurisdiction. They're not discussing that whole issue. So you see here how the state here is completely, and again, I'm not taking sides on any of this. I just actually did the research, which a lot of other people don't do. And if you actually do the research, you see that this Stiger court, this holding, this is the crux of their argument, really has nothing to do with the ultimate issue here, which is when should the appellate court grant a motion to relinquish the jurisdiction? Okay, so I hope that's clear. Now let's move on. So now they're going to argue, well, in case the appellate court actually reads this Stiger decision and they agree with brother counsel and they say, hey, Stiger has nothing to do with this issue. Well, they're going to now argue that even in the discretion of the court, according to what the appellate courts, the appellate attorneys for Charlie Adelson's, their motion, they're arguing that they should exercise this jurisdiction and relinquish jurisdiction. They're going to argue against that now. All right, so here we go. This court should refuse to exercise discretion to relinquish jurisdiction. The Meneses court made clear that an appellate court's authority to relinquish jurisdiction is discretionary. Yep, that's true. We said that. Meneses held that the filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. This is what we discussed. The Meneses court also noted that the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis. So you could, again, we spoke about this in our last video, but just to reiterate the point, the appellate court is not in the business of deciding motions to vacate. That's not really what they do. That's what the trial court level is supposed to do. Now, in this specific instance, when you want to file this motion to relinquish jurisdiction based on a future motion to vacate, well, then the appellate court does have the authority to evaluate that what they believe this motion to vacate is based on. And if they find that it's frivolous, then they can decide, you know what, we're going to exercise that discretion and not relinquish our jurisdiction because you're just wasting everybody's time here. So they are able to do that. So again, they're just pointing out that if it's frivolous, then you definitely have the discretion, the appellate courts have the discretion not to relinquish jurisdiction. Adelson's grounds are speculative and therefore frivolous. Even if this court could relinquish jurisdiction under Meneses, Adelson has given this court no reason to do so. Adelson's motion provides this court with no blueprint for how his case would proceed if placed back in the trial court. And again, I don't really understand what they're talking about. This is a recognized motion that you could file. This is a motion based on 3.850. You can have an evidentiary hearing. I mean, they're pretending like this is their first week practicing law. Like, oh, I wonder what type of procedure they would employ if they would go back to the trial court. I'll tell you exactly. They'd file a motion, and then the judge will make a determination whether there is necessary to have a evidentiary hearing. There's going to be an evidentiary hearing, and then the judge will ultimately make a decision. That is how this all works out. So don't pretend like you don't know. Like, it's one thing if you actually know what you're talking about and you say, I don't even know what they're even asking for. Okay, that's one thing. But here it's very clear. Like, if you actually look through some of the case law and you look at the rules, this is the proper procedure. So again, I don't know why they're doing this. At a minimum, Adelson's motion should have demonstrated two things. First, that further proceedings in the trial court will reveal that Rashbaum had an actual conflict of interest. Second, Adelson should explain why his conflict of interest claim would not be better addressed in a post-conviction motion. So that's their second issue. Their second point here, I guess, is going back to what they were arguing about Strickland, which we already took care of on our own before. But anyway, let's continue. Because Adelson did not raise his conflict of interest claim in the trial court, Adelson cannot raise Rashbaum's conflict of interest on direct appeal unless Rashbaum had an actual conflict of interest. Now, that is true. If you want to just raise conflict of interest on appeal, that is what the Stiger court is talking about. That's not what they're looking to do here. They're not looking to raise this issue of conflict of interest and put it in front of the appellate courts. That's not what they're doing. What they want to do is pause it and send it back to the trial court. Okay, so again, they're convoluting these two issues, but this is what they're arguing. And again, in order to establish a violation of the Sixth Amendment, a defendant who raised no objection at a trial must demonstrate that an actual conflict of interest adversely affected his lawyer's performance. Kyler versus Sullivan. Remember that case, Kyler versus Sullivan, which we mentioned earlier? That actually is the case. If you want to know, this is the site right here. Take a look at that case. It's very long, but you don't have to read the whole thing. You just read the part about the conflict of interest. But that is the case that's talking about conflict of interest and ineffective assistance of counsel based on conflict of interest. So this is the best case to read. Anyway, however, an actual conflict of interest means precisely a conflict that affected counsel's performance as opposed to a mere theoretical division of loyalty. So then it basically talks to you, Kyler versus Sullivan does talk to you about what does it mean an actual conflict of interest, and it goes through some of the analysis on that. So you can definitely take a look at that. But we're not even there yet. We're really not so much there at what exactly is necessary to prove that there's ineffective assistance of counsel. Right now, they just want the opportunity to present the issue in front of the trial courts, the trial court level. Okay. All right. So yeah, it has to be an actual conflict of interest, which we're going to see probably more about later, as opposed to a theoretical conflict. Is this a theoretical conflict or is this an actual conflict? Adelson's motion is insufficient because it cites the possibility of a conflict of interest, but does not hint at how that conflict prejudiced the outcome of his case. But they really did. They really did talk about that, right? Because they talked about how if Donna Adelson would have gotten the stand, if Dan Rashbaum would have not removed her from the witness list and had her testify on behalf of Charlie Adelson and to be able to support and corroborate his version of this double extortion theory, it could have helped. So it's not, they're not hinting at it. They said it straight out in their brief. But anyway, but the possibility of a conflict is insufficient to impugn a criminal conviction. That's true, right? So the possibility of a conflict is not enough. It has to be an actual conflict. Okay, that's what Kyler says. The Supreme Court explained the reason for this and how even a trial court's awareness of a potential conflict is insufficient for a Sixth Amendment violation. The trial court's awareness of a potential conflict neither renders it more likely that counsel's performance was significantly affected, nor in any other way renders the verdict unreliable. Okay, all this case law. In fact, a potential conflict can work to defendant's advantage. Okay, so a potential conflict could work to your advantage by ensuring that a jointly represented co-defendant does not cooperate with law enforcement. Okay, there's other ways, you could work the conflict to your advantage. Such joint representation may provide a common defense. So they're just saying, just because Dan Rashbaum could have been representing Donna Adelson as well as Charlie Adelson doesn't automatically mean that there's a conflict. Okay, it is possible to represent two people, two co-defendants in a single case, have one theory of the defense, and argue for both of them. You could do that. Again, it's not suggested, but it doesn't automatically mean that when you're representing two co-defendants, that means that there's automatically a conflict of interest. So they're just pointing that out with some of these cases that they're citing. The facts alleged in Adelson's motion are insufficient to even support an ineffective assistance of counsel's claim. Until defendant shows that his counsel actively represented conflicting interests, he has not established the constitutional predicate for his claim of ineffective assistance. So this is all they're arguing to say that this is all frivolous. This is frivolous because even all of their factual allegations that they're making in their motion does not support an ineffective assistance of counsel claim. This is what the state is moving towards, that even if we were to accept that they're right on the law, which they're mostly right about, they're still going to argue that it would be frivolous to send it back to the trial court because they cannot win on this claim of ineffective assistance of counsel. The Florida Supreme Court in State versus Alexis held that a showing in effect on counsel's performance is essential to showing an actual conflict of interest. A theoretical conflict is almost always present in cases of multiple representation. Okay, back to the theoretical conflict is not enough. It has to actually be an actual conflict. At best, Adelson alleges a theoretical conflict of interest that would be better explored through the normal post-conviction claim process. They really want them to just wait till everything's done and then file your post-conviction claim, which is going to get denied. So that's really what they want to do. So they keep saying that this is just a theoretical conflict. But again, it's not so theoretical if the reason why Dan Rashman did not put Donna Adelson on the stand is because he was protecting her interest over his own client, Charlie Adelson's interest at the time of that trial. And that can come out through evidentiary hearing. You can ask Dan Rashman, why didn't you put Donna Adelson on the stand? So if this all comes out, then you're right. This wasn't an actual conflict of interest. But if there's enough under argument that there can really be an actual conflict of interest, then definitely there should be some sort of motion in the trial court level and some evidentiary hearing. The record contained in Adelson's own appendix shows why Adelson's conflict argument is premature, and therefore his motion should be denied. Both Charlie and Donna Adelson waived any conflict arising from Rashbaum representing both co-defendants during separate trials. Okay, so now they're arguing now, the state, is that they waived all the conflicts. They waived all the conflicts. But when? Was this waiver in place before Charlie Adelson's trial or just before Donna Adelson's trial? Let's see if they talk about that. But before jury selection in Donna Adelson's case, okay, that we know, Charlie Adelson revoked his waiver of the potential conflict. During that jury selection, attorney Laurel Niles, Charlie Adelson's appellate attorney, stated that when they received the subpoena for Charlie Adelson's trial testimony, they spoke to him about invoking his rights, right? That's what we remember from that hearing. Niles recognized that a potential conflict would only arise if Charlie Adelson took the stand as a state witness and faced cross-examination from Donna Adelson's attorneys, right? That's what we spoke about. The potential for the conflict of interest, why Dan Rashbaum had to bow out, is because you cannot represent Donna Adelson and have Charlie Adelson on the stand, and now you have to cross-examine your former client. We spoke about this ad nauseum already, so you already know all this. But this is where the potential conflict would arise, which is why Charlie Adelson had to leave. I'm sorry, Dan Rashbaum had to withdraw, particularly Rashbaum. Niles stated that the potential for conflict was always there, but the conflict arose. It's going to arise on the witness stand. It has not quite yet arisen, but potential for conflict is there. Thus, even during the hearing which resulted in attorney Rashbaum's removal from Donna Adelson's case, Charlie Adelson recognized that there was a potential for a conflict if he testified, but Charlie Adelson did not assert that there was an actual conflict. So again, they're saying this is all potential, this is all theoretical, this is not an actual conflict. You're right that they are right that this is a potential for conflict. But a potential for conflict doesn't mean that there's not an actual conflict that exists right now. There is an actual conflict. It's going to play out when he takes the stand. Okay, that doesn't mean that there's not an actual conflict. But anyway, let's continue. In his motion to relinquish jurisdiction, Charlie Adelson appears to rely on the fact that both the state and Rashbaum listed Donna Adelson as a witness for Charlie Adelson's trial, right? This is where a lot of the basis of the motion is. That Charlie Adelson didn't get a fair trial because Donna Adelson was listed as a witness and then was taken off. Rashbaum, however, removed Donna from the witness list before Charlie Adelson's trial began. Charlie Adelson motion speculates that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interest, i.e. not being interviewed by the state, right? That's most likely. I mean, that's a very obvious reason why he would not want Donna Adelson on the witness list if the state can interview her, and against Charlie Adelson's interest, having i.e. a witness that could have corroborated Charles Adelson's testimony was not called by Mr. Rashbaum. This speculative claim is a poor reason to put this appeal on hold and send Charlie Adelson's case back to trial court. Well, I don't know. I'm not sure if it's a poor reason. I think it's pretty decent, but let's move on. Charlie Adelson cites an October 12, 2023 motion hearing where attorney Mauricio Descalzo appeared on behalf of Donna Adelson, who was then a potential witness in Charlie Adelson's trial alongside her husband, Harvey Adelson. Attorney Descalzo had concerns about the state seeking to interview Donna and Harvey Adelson. Rashbaum, then representing Charlie Adelson, explained to the court that he had included Donna Adelson on his witness list after the state had sought to interview her. So here, Dan Rashbaum is saying, well, I included Donna Adelson on the witness list because the state sought to interview her. And then attorney Rashbaum believed that the state had sought to interview Donna as an end run around the discovery rule. Rashbaum complained that the state had years to interview Donna Adelson, but only sought an interview immediately before trial. Rashbaum stated that he would remove Donna from the witness list if she was not going to be interviewed, but Rashbaum added that he listed Donna as a witness as a protection for myself to put them on there. So that's what Dan actually said, and this is what they're quoting from. That's why he put Donna on the witness, just as a protection to put them on there. So no further explanation there. The court asked if anyone was planning on calling Donna Adelson, and Rashbaum explained that he did not intend on calling Donna Adelson. But that's exactly the point. Why wouldn't you call Donna Adelson if you just care? Which is what Charlie Adelson's attorney should just care about. If you just care about your client and keeping Charlie Adelson out of jail and corroborating the story, then why wouldn't you call Donna Adelson? So you got to explain that. But anyway, let's continue. Rashbaum further accused the state of gamesmanship, claiming that the state did not intend on calling Donna, but instead they were trying to get an interview now on the eve of trial, frankly, to figure out what my defense is. The prosecutor, Ms. Koppelman, responded to Rashbaum's accusation, stating that Donna and Harvey Adelson had never made themselves available for an interview. Koppelman said that she reached out to the Adelsons to nail down the fact that they were going to invoke their Fifth Amendment right against self-incrimination. Donna Adelson responded that she was going to invoke the Fifth for pretrial purposes, but not for trial. This response led Koppelman to believe that the Adelsons were going to testify for the defense. Koppelman stated that she was, okay, so that's what Donna said. Donna said, well, I'm going to invoke my Fifth Amendment rights for pretrial purposes, but during the trial, I'm going to be happy to take the stand. So Koppelman understood, right? Georgia Koppelman understood, okay, so now you actually are planning on testifying. So Koppelman stated that she was seeking to interview Donna and Harvey Adelson prior to trial to see if they were going to invoke, but she did not know if she would call them because they never made a statement. Thereafter, the parties stipulated that neither the state nor defense would call Donna or Harvey Adelson as a witness. So that's kind of how this all came about, with Donna Adelson being put on the witness list and taken off the witness list. Does she want to give an interview? Does she not want to give an interview? Does she want to invoke her Fifth Amendment rights? Is she going to plan on testifying during Charlie's trial or not? This was all being discussed at the time. So this is what the state argues based on that. Thus, the record shows that Rashbaum did not remove Donna Adelson from the witness list to protect her interest and thereby undermine Charlie Adelson's defense. Now, how they came to that conclusion, I don't understand. Again, the record shows that Rashbaum did not remove Adelson. How do you know why he did not remove Adelson from the witness list? That is what he's saying in court. But do you know for sure that in the back of his mind, he didn't want Donna Adelson testifying because he had this conflict? All right. In fact, attorney Rashbaum had never intended on calling Donna Adelson as a witness. Instead, Rashbaum only listed Donna Adelson as a defense witness when he learned that the state was intending on interviewing her. Rashbaum believed that the state was attempting to avoid discovery and gain insight into Charlie Adelson's defense. Well, that's what he said. He argued that the state is just trying to learn about Charlie Adelson's defense. These facts fail to show that attorney Rashbaum changed his defense strategy to benefit Donna Adelson to the detriment of Charlie Adelson. And even if Rashbaum had intended on calling Donna Adelson as a witness, there would only be a conflict if Donna Adelson's defense was detrimental to Charles Adelson's case. There's no evidence of that. Well, again, I don't follow this exact logic 100%. Maybe some of you do. But again, the point is that if Donna Adelson would have taken the stand, it would have helped Charlie. And if there's any reason at all that she did not take the stand because Dan wanted to protect her in the slightest for any reason at all, that is a conflict of interest that goes against Charlie Adelson's interest in his case. Rashbaum's representation of both Donna and Charles Adelson was no more conflicted than the dual representation at issue in State versus Alexis. Alexis and co-defendant Gurrier were represented by the same attorney at trial. So again, now they're citing a case where you have two co-defendants that were represented at the same attorney at trial, and there was no conflict. That was a problem there. The victim and another witness testified that Alexis or Guerrero had pulled the victim out of a car and pointed a gun at him. So we have these two co-defendants, Alexis and Gurrier, and the victim, another witness testified that one of them pulled him out of the car, pointed the gun at him. Guerrero had made a statement at trial that both he and Alexis had asked the victim to get out of the car, which was occupied by a female friend of theirs, and Alexis had pulled him out of the car. Both defendants testified at trial that they had jointly pulled the victim out of the car, but neither displayed a gun during the encounter. The state had argued that since the co-defendants' respective defenses were compatible rather than conflicting, they both admitted pulling the victim from the car. They both denied being armed, and neither claimed the other was armed. The dual representation did not create a conflict of interest between respondent and his attorney. Well, in that case, you're right. They had the same exact defense, and therefore there was no conflict between Don Adelson and Charlie Adelson. I'm sorry. In with these two defendants, there was no issue. So if we find out that you're right, that the defenses were going to be exactly the same between Don Adelson and Charlie Adelson, then that's a possibility that you can make the argument that there's no conflict of interest here. The difference is that in this case, in Alexis's case, both co-defendants took the stand. They took the stand and testified to the same thing. So then the judge said, okay, well, where exactly is the conflict here? You both had the same exact defense, and we don't see any sort of conflict there. So then there was no conflict of interest, and there was no, therefore, any argument of ineffective assistance of counsel. But in this case, we don't know what Don Adelson would have said, and we don't know why she was taken off of that witness list, except for some very, very small, brief comments that Dan Rashbaum made, which, again, was not probing exactly into all of his thought process about why he didn't call Don Adelson. So that would be more appropriate at a future evidentiary hearing, and then maybe we can see whether there was maybe a conflict of interest that was actually present there, and which is why Dan Rashbaum didn't call Don Adelson. So we don't know that yet, and therefore, a lot of this is just logic that I don't really follow 100%, and some of it I think is quite weak. But this is the state's response to Charlie Adelson's motion for the appellate courts to relinquish the jurisdiction and send it back. They're arguing essentially that it's all frivolous anyway, because there's no real conflict of interest. There's never an actual conflict of interest. It was all just theoretical and probable, and that's not enough that shouldn't be enough for the appellate courts to exercise its discretion in sending it back to the trial court. So that's the state's response. There's a very, very short reply filed back by Charlie Adelson's appellate attorneys. Nothing too exciting. Just arguing just a very briefly back. But we've kind of really did a deep dive on the arguments back and forth. So we'll see eventually what the Court of Appeals does. And that is going to be it for now. Please, if you haven't yet, subscribe, like the video, and of course, we will be following this, and we will see you next time.